President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators, I have granted leave of absence to Senator the Honourable Paula Gopi-Schoon, who is out of the country, and to Senator Daniel Duque, who is ill. Honourable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Alicia Romano. Whereas Senator the Honourable Paula Gopi-Schoon is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Alicia Romano, to be temporarily a member of the Senate with effect from the 18th of May 2018 and continuing during the absence from Trinidad and Tobago of the said Senator the Honourable Paula Gopi-Schoon. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, the 17th day of May 2018. To Ms. Ayana Liba-Lewis. Whereas Senator Daniel Duque is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ayana Liba-Lewis, to be temporarily a member of the Senate with effect from the 18th of May 2018 and continuing during the absence of Senator Duque by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 17th day of May 2018. Honourable Senators, Senators are required to take leave.
I, Alicia Romano, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ayana Lewis, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I'm about to enter.
Bills brought from the House of Representatives. Petitions, papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the name of the Minister of Finance. The annual audited financial statements of the National Schools Dietary Services Limited for the financial year September 30, 2017. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the National Institute of Higher Education, Research, Science and Technology for the year ended December 31st, 2011. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Telecommunications Authority of Trinidad and Tobago for the year ended September 30, 2012. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Children's Life Fund for the year ended September 30, 2013. The annual report of First Citizens Bank Limited for the year 2017. And the second report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Sugar Industry Labour Welfare Committee for the year ended September 30, 2003. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Health, the Minister of National Security, the Minister of Social Development and Family Services, and the Minister of Public Administration and Communication. The ministerial response of the Ministry of Health to the 10th report of the Public Accounts Committee, 3rd session 2017-2018, 11 Parliament, on the examination of the audited financial statements of the Eastern Regional Health Authority for the financial year 2008 to 2013. The ministerial response of the Ministry of National Security to the 7th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session 2017 to 2018, 11 Parliament, on the status of the implementation of the recommendation of the 2015 report on the examination of programs and services which provide support to victims of domestic violence. The ministerial response of the Ministry of Social Development and Family Services to the 7th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session 2017-2018, 11 Parliament, on the status of the implementation of the recommendations of the 2015 report on the examination of programs and services which provide support to victims of domestic violence. And finally, Madam President, the ministerial response of the Ministry of Public Administration and Communication to the 7th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, 3rd session 2017-2018, 11 Parliament, on an inquiry into the efficiency and effectiveness of the Public Service Commission.
Reports from committees.
Senator Amin.
Thank you, Madam President. I have the honor to present the following report as listed on the order paper in my name. The fifth report of the Joint Select Committee on Social Services and Public Administration, third session 2017-2018, 11th Parliament, on an inquiry into the adverse health effects of fireworks.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of National Security, does the government intend to legalize pepper spray in Trinidad and Tobago?
Minister of National Security.
Thank you very much, Madam President. Madam President, based on discussions between the Minister of National Security and the Commissioner of Police, the Trinidad and Tobago Police Service is in fact conducting assessment and analysis of the use of non-lethal responses, including pepper spray. On completion of those investigation and analysis, recommendation will be submitted and dealt with accordingly.
Senator Mark.
Madam President, in light of the urgency of this situation, particularly affecting our women folk, would the Minister want to advise his Honourable House what time frame he anticipates for the submission of that report, Madam President?
Minister of National Security.
Madam President, the question of non-lethal use of weapons has been always there, and I'm sure that we'll do it in a shorter time frame than the last administration.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Prime Minister, having regard to the incident in which a falling tree branch struck a 5-year-old Tobago student, can the Prime Minister indicate if the child's medical expenses will be met by the Tobago House of Assembly?
Minister in the Office of the Prime Minister.
Thank you, Madam President. Madam President, I join the Tobago House of Assembly in expressing deep regret over this incident. 5-year-old Zakiya Lord is presently being cared for in the intensive care unit of the Scarborough General Hospital. The cost of her care forms part of the operating budget of the hospital.
Senator Mark.
Madam President, could the Honourable Minister indicate whether any investigation will be conducted into this whole matter and to determine who was liable, who was responsible?
Senator Mark, I won't allow that question. Next question, Senator Mark.
To the Honourable Minister of Education, can the Minister indicate if any action has been taken in relation to reports that a teacher in South Trinidad inflicted corporal punishment on his students?
Leader of Government Business.
Thank you very much, Madam President. Madam President, the incident in which it was alleged that a teacher in South Trinidad inflicted corporal punishment on his student was brought to the attention of the Ministry of Education. A school supervisor has been assigned to investigate the matter and to submit a report, following which appropriate follow-up action will be taken if necessary.
Senator Mark.
Madam President, can the Honourable Minister indicate whether a system is in place to monitor the behavior of teachers, particularly as it relates to the use of corporal punishment in schools in Trinidad and Tobago?
Minister.
Madam President, there is a system of supervision to teachers through the school supervisors, and that system is already in place, and matters are handled on a case-by-case basis.
Next question, Senator Haynes.
To the Minister of Education. Based on reports by Tutor that the primary schools have not received direct funding for the current academic year and are unable to purchase basic school supplies and toiletries, Can the Minister indicate when this will be rectified?
Leader of Government Business.
Madam President, for fiscal year 2018, the Ministry of Education has remitted funds to the boards of management of denominational schools, payments for term 1 and 2 with respect to grants to assisted primary schools for school equipment and upkeep of school premises. Payments for requisite and office stationery supplies remain outstanding due to the non-receipt of releases. Upon the receipt of releases, which I understand is imminent, this matter will be rectified. For government primary schools, with respect to office stationery and supplies, including toiletries, the Ministry has processed and remitted funds to principals of approximately 50% of the allocation received for this academic year.
Given that we are halfway, well, almost to the end of the academic year, is any consideration being given to reimbursing teachers who would have made purchases for school supplies?
Business.
Not to my knowledge, but I think some appropriate arrangement will be made when the releases are finally made.
Yeah, Senator Haynes.
And is there any preventative measures that would be put in place to avoid this occurring in the next academic year?
Leader of Government Business.
Well, the preventative measures are already in place. All these supposed hitches in releases obviously has to deal with the government cash flow. And for those of you who have been following the mid-year budget review, we don't expect to be experiencing these acute cash flow problems in the next fiscal year.
Next question, Senator Haynes.
Thank you. To the Minister of National Security. In light of a recent video showing remand prisoners in a cell with contraband items, can the Minister advise as to how this happened and what is being done to prevent a reoccurrence?
Minister of National Security.
Thank you, Madam President. Madam President, the Commissioner of Prisons has launched an investigation in this matter. The investigation is still ongoing. Until such time as the investigation is completed, I'll best be able to answer, Senator.
Senator Haynes.
Thank you for that response, Minister, and I do look forward to the update. But given that this is one of several videos recorded on cell phones in the prisons, what has been done to address the presence of cell phones in the prison system?
Minister of National Security.
Madam President, there are several measures that have been used and continue to be used with respect to cell phones in the prisons. The jammers and scanners are being instituted. The Prisons Commissioner has instituted serious measures with respect to officers on duty within the prison system. There are various checks that are made of persons entering the prison, including prison officers themselves, and several other measures have been put in place to treat this matter, and we continue to do so, Madam President.
Senator Haynes.
Thank you, Minister. And given that these measures have been put in place, can the Minister state if there's a report on the effectiveness of the measures, given the reoccurrence?
Minister of National Security.
Madam President, we continue to evaluate these measures as we go along and treat with the issues. The Prisons Commissioner continue to treat with these measures very urgently, and as they occur, he will put different measures in place to treat with them, Madam President.
Questions on notice. Questions for oral answer.
Leader of Government Business.
Madam President, the government is pleased to announce that it will be answering questions 122, 123, and 124.
Senator Mark.
I can ask all my questions now?
122, 123, and 124 are all your questions.
Thank you, ma'am.
Senator Mark.
Yes, thank you very much, Madam President. Question number 122 to the Honorable Minister of Housing and Urban Development.
Acting Prime Minister.
Thank you, Madam President. No recent survey was undertaken by the Ministry of Housing and Urban Development at the North Grove Housing Development, which is located at the Southern Main Road, St. Augustine, and is an extension of the general development in the Kirep-Valsane area. The North Grove Housing Development does not require the approval of Parliament. The National Physical Development Plan of 1984 received the approval of Parliament. This guides the development of all land in Trinidad and Tobago. The Town and Country Planning Division, through its land use policies and approval process, considers whether a proposal such as the North Grove housing development is in line with the approved National Physical Development Plan and the current land use policy for an area. Further, under the Town and Country Planning Act, Chapter 3501, the minister responsible for town and country planning can amend the land use policy for an area. Outline planning permission was granted to the North Grove housing development proposal on October the 12th, 2017.
Senator Mark?
Yeah, Madam President, having regard to the fact that the National Physical Plan was executed in 1984, can the minister indicate whether the government intends to revisit that physical development plan?
Senator Mark, that question does not arise. Next supplementary. Okay. Next question, Senator Mark.
Question number 123 to the Minister of Housing and Urban Development.
Acting Prime Minister.
Thank you, Madam President. The Samuel Laventel Regional Corporation attended a public consultation meeting at the Ministry of Housing and Urban Development on the 20th of December 2017. Other key stakeholders, inclusive of representatives from the Agricultural Society of Trinidad and Tobago, various government ministries, the Trinidad and Tobago Farmers Union, residents and neighboring businesses were invited to the public consultations held by the housing development on the 9th and 29th of February 2018. At all of these consultations, all present were given an opportunity to make comments and representations. And I might say that the Samoa Regional Corporation is currently controlled by the People's National Movement, as is the Tunapuna Piako Regional Corporation. So there will be further consultations.
Senator Mark.
Madam President, could the Honourable Minister indicate to this House whether, in light of these objections, in accordance with the representation, the consultation, Madam President, there were objections at those consultations. So I'm saying to the Honourable Minister, in light of those consultations and objections that were executed at that meeting, whether the minister intends to enforce the relevant section of the legislation by setting up a committee to look into those matters.
Right, Senator Mark, let me give you a little help here. The question didn't say anything about objections. So I think you can ask whether there were any objections, and there were several meetings referred to in the answer, so you have to specify which meeting, because you asked a supplementary about that. So now you can proceed.
Well, Madam President, what is happening is that in light of the consultations that were held, can the minister indicate to this House whether the Tunapuna Regional Corporation, which falls within the boundaries of that corporation, has been consulted by the government?
Acting Prime Minister.
Madam Speaker, I'm sorry, I cannot accept anything said by the Honourable Senator with respect to the boundaries of the corporations. I'll have to check that, because the information given to me is that the Samoa Regional Corporation attended the consultation. So that I am not certain that the assertion that this development falls within the Tunapuna Piako Regional Corporation is correct. But be that as it may, as I indicated, both the Samoa Regional Corporation and the Tunapuna Piako Regional Corporation are currently controlled by the People's National Movement, and there will be further consultations.
Senator Mark, yes.
Yeah, Madam President, I would like to advise the Honourable Minister, since he has been misled and misguided, that the St. Augustine, yes, I am indicating to you that the Tunapuna Regional Corporation is responsible for that area. Yeah. So I'm asking you, based on your consultations, whether you have specifically consulted with the Tunapuna Regional Corporation. That's the point I'm making, Madam President.
Yes, but Senator Mark, the Acting Prime Minister answered that question a while ago. So can you ask another question?
Madam President,
Well,
with disrespect.
Okay, just have a seat, please. Acting Prime Minister, we are on to your third supplemental question, Senator Mark. The minister did talk about the Tunapuna. He said he was not aware of whether, but that further consultations may be held. That's what I understood the answer. Third supplementary question, Senator Mark.
Does the Honourable Minister intend through those bodies and the National Housing, the Housing Development Corporation, intend to hold any further consultations consistent with the legislation, Madam President?
Acting Prime Minister.
Madam President, as I've said twice, and I'll now say thrice, the Samoa Regional Corporation and the Tunapuna Piako Regional Corporation are currently both controlled by the People's National Movement, which also forms the government at this time. And there will be further consultations with those two corporations. I can say it a fourth time if you wish.
Acting Prime Minister, thank you. Senator Mark, any more? No. Next question, Senator Mark.
Question number 124 to the Minister of Housing and Urban Development.
Acting Prime Minister.
Thank you, Madam President. Notices with respect to the Housing Development Corporation, ongoing public consultations on the proposed North Grove housing development in Curep can be found in the daily newspapers, namely the Express, the Trinidad and Tobago Newsday, and the Trinidad and Tobago Guardian, dated the 20th of April 2018. Additionally, members of the public can access the proposals and plans for the North Grove site on the Housing Development Corporation's website.
Can the Honourable Minister indicate, in accordance with the law, Section 7, subsection 2 of the Town and Country Planning Act, Chapter 3501, whether he has published that in the Gazette of the Republic of TNT? And if not, why not?
Acting Prime Minister.
Madam President, I do not have that information at this time. The information I have is that the notices were published in the Express, Newsday, and Guardian. But I will ascertain the response to that question for the Honourable Senator in due course.
Madam President, in light of the law, can the Honourable Minister indicate to this Honourable House that he will make available in writing, in the shortest possible time, this conformity to the law by the HDC? Can he give us that undertaking? Because it's part of the law.
Madam President, in the same way I do not trust the Honourable Senator's geography, I do not trust his knowledge and interpretation of the law, which I happen to have in front of me. And the relevant law that the senator has quoted is the Town and Country Planning Act, Chapter 3501. And if one goes to the interpretation of this act, one would see that the minister referred to in the act is the minister responsible for town and country planning. And if one then goes to Section 7.2 of the Town and Country Planning Act, one will see that the person who is required to ensure that a notice is published in the Gazette and at least one daily newspaper is the Minister of Planning and Development and not the Housing Development Corporation. So there is no breach of the law on the part of the Housing Development Corporation as alleged by the Honourable Senator. And further, Section 7.2 refers to a special or specific development plan for a particular area of Trinidad and Tobago and has nothing to do with the matters raised by the Honourable Senator.
Is the minister aware that the Minister of Planning and Development, seeing that he's answering this question, has published in the Gazette such a notice?
Senator Mark, I think that question has already been answered before. Yeah, next supplemental question, Senator Mark. Yeah, I think, yeah. Thanks.
Public business, government business, bills second reading.
You all just let me know when you all are ready for me to begin our formal proceedings. Thank you. Minister of Finance.
Thank you, Madam President. And Madam President, let me say at the outset, I have with me the Honorable Attorney General, and of course the Minister and the Ministry of Finance is a member of this House. And it is my intention as the chairman of the Yes, I know. It is my intention as the chairman of this committee simply to make my introduction and then take my leave. I do not wish to be in breach of this standing order, so I'm just saying that now. And my honorable colleagues will ably represent the government afterwards. I beg to move that a bill entitled An Act to Repeal and Replace the Insurance Act, Chapter 8401, to reform the law relating to insurance companies, to regulate insurance businesses, and privately administered pension fund plans, and for other related purposes be now read a second time. As I indicated, Madam President, I have the Honorable Attorney General with me, who was a member of the Joint Select Committee on the Insurance Bill 2016. And may I read into the record the other members? So it was myself as chairman, and in addition, Mr. Faris Alwari, Ms. Marlene MacDonald, Mr. David Lee, Dr. Surajatan Rambachan, Mr. Clarence Rambarat, Mr. Daniel Duki, Dr. Lester Henry, Mr. Wayne Sturge, Mr. Stephen Crease, and Ms. Jennifer Raful. So it appears that the only persons who are present here with us today who were members of that committee would be myself and Mr. Alwari. Unfortunately, neither Mr. Crease nor Ms. Raful are here yet for the session. Hopefully, I don't know if I missed anything, but I hope they will be present in due course. Because I want to say, Madam President, we as a parliament have been at this job for years. I think we had 3 committees or 2 committees, but it was 5 committees. 5 bills, 2 committees. Wow. And I remember my predecessor in the Ministry of Finance convening a committee, and we reached pretty far because it's a very large bill. It's a very, very thick document, and I think there are over 200 clauses from my memory. 282, yes. And schedules and so on. And the previous committees took years, and this committee also took quite some time, but we benefited tremendously from the participation of all members concerned, including and especially members of the opposition and members of the independent bench. So I'd like to thank the members of the opposition who participated in the committee's deliberations, and also the members of the independent bench who also participated, as well as members on our side, of course, especially the Attorney General, Minister Rambarat, Ms. MacDonald, Mr. Duki, Dr. Henry, and so on. The purpose of the bill is to reform, transform insurance legislation. And might I also say we had unanimous agreement in the other place on this legislation. And it's special majority legislation, so I was very heartened that we could all come together as a parliament, government, opposition, and independents, and reach consensus on such a complex bill with over 200 clauses. The bill before you represents many years of analysis, research, and consultation with various stakeholders, supplemented by long hours of deliberation by the Joint Select Committee, which was appointed to consider and report on the Insurance Bill 2016. It's very disappointing, Madam President, I think we're all disappointed, that in the aftermath of the CL financial CLICO crisis of 2009, that our insurance sector is still being governed by woefully deficient legislation, which dates back to 1980, almost 40 years, and which cannot adequately address the current emerging risks in today's insurance sector. By contrast, the banking and securities sectors are governed by far more modern legislation, such as the Financial Institutions Act and the Securities Act, which were enacted in 2008 and 2012, respectively. However, for effective supervision, the industry needs to operate under relevant legislation. The financial sector is only as strong as its weakest link, as we saw again in the CL financial CLICO crisis of 2009. Trinidad and Tobago is widely regarded as the financial center of the Caribbean. And yet, and it bears repeating, our insurance legislation lags way behind our Caribbean counterparts. Jamaica, for example, underwent major institutional and legislative reform following its 1990 financial crisis, which cost that country approximately 30% of its GDP. So Jamaica is ahead of us in terms of legislation and institutional arrangements for supervision of the insurance industry. We must learn from our own costly problem with CLICO. We must enact appropriate legislation for the insurance industry. In 2009, the central bank was successful in fast-tracking certain specific amendments to the Insurance Act of 1980, but that was a crisis approach. That was a reaction to the problem that occurred with CL Financial and Colonial Life. The amendments were extracted from the proposed insurance legislation at the time because the matter had been under discussion for years. So there was draft legislation floating around at all times and enacted in order to treat urgently with burning issues at the time. The issues were enhancement of the provisions governing assets to be placed in a statutory fund by requiring insurance companies carrying on long-term insurance business or motor vehicle insurance business to have sufficient assets in their statutory fund to meet their policyholder liabilities as established in their quarterly returns. Additionally, strengthening of the provisions to afford the central bank access to the premises of an insurance company if the bank was physically prevented from entering. Replacement of the intervention process, which was time-consuming and hindered the effectiveness of the regulatory process. The process was replaced with a more flexible regime which allows the central bank to issue compliance directions. All of these things came out of the CLICO collapse. Replacement of the costly and time-consuming process of judicial management with the suspension process, which facilitates remedial regulatory action, and permitting the central bank to share information with other regulators, both within Trinidad and Tobago as well as other jurisdictions, where insurance companies registered in Trinidad and Tobago also conduct business. However, after that, efforts continued in the formulation of a completely new bill, rather than the piecemeal amendments that had taken place. For example, the Insurance Bill 2011 was laid in Parliament on the 25th of November 2011, but unfortunately lapsed on the 26th of June 2012. Parliament then did it again. The Insurance Bill 2013 was laid in Parliament on the 28th of May 2013 and lapsed on the 10th of July 2013. The Insurance Number 2 Bill 2013 was laid in Parliament on the 19th of November 2013 and lapsed on the 30th of July 2014. The Insurance Bill 2015 was laid in Parliament on the 21st of April 2015 and lapsed on the 17th of June 2015. So when one looks at this, Madam President, in the Parliament before us, there were four attempts to pass insurance legislation, all of which failed. Finally, the Insurance Bill 2016 was introduced in the House of Representatives on the 1st of July 2016, so that's almost 2 years ago. So we've been at this for a very, very long time. It represents the product of the previous Parliament's work, including the work of Joint Select Committees, and I had the privilege to be on previous Joint Select Committees, as did the Attorney General. The bill now before the House, as I indicated, is the product of the work of a tripartisan committee on which everyone contributed, and we reached complete consensus on every single issue. This is why the bill was passed through the other place with a special majority without amendments. Madam Speaker, the existence of a sound insurance market will facilitate the financial goals of individuals as well as the business community by protecting the society's assets. I don't need to underscore that. Insurance and pension industries are long-term investors in projects, businesses, and infrastructure, and thereby facilitate sustainable growth and economic development. As at the 30th of September 2017, the assets of the insurance industry in Trinidad and Tobago total almost $50 billion, $49.4 billion to be exact. And they account for 33% of the GDP of Trinidad and Tobago at this point in time. Assets under management for the pension sector total $51.4 billion and account for 34% of GDP. The combined assets of the insurance and pension sectors are thus of the order of 100 billion Trinidad and Tobago dollars, of which more than 1/3 is invested in securities of the government of Trinidad and Tobago. Consequently, the importance of the insurance industry is not only related to its size, but also to its interconnectivity with other financial institutions and sectors of the economy. I'd like now to point out a few major gaps in existing legislation. The existing Insurance Act of 1980, which clearly demonstrate why we need to have new legislation. The current legislation does not require insurance companies to maintain adequate capital buffers for the risks on their balance sheet. In fact, insurance companies carrying on long-term insurance business are required to have share capital of a mere $3 million. And I'm sure members realize how absurd that is. So insurance companies are running businesses in the hundreds of millions of dollars, in the billions, because I am familiar with an insurance company where its share value would be somewhere in the region of $3 billion, a local insurance company. So that currently, insurance companies are only required to have a share capital of $3 million, which certainly cannot provide companies with the necessary buffers to withstand shocks or adverse circumstances. General insurance companies are required to have a share capital of only $1 million, which is ridiculous. This has not changed. That could be one claim alone. This has not changed since 1980 and is unacceptable in today's climate, where companies are holding millions, and I indicated billions, of policyholders' funds. Additionally, the existing insurance legislation lacks adequate provisions to ensure the effective governance and risk management of insurance companies. There may exist significant deficiencies among our companies in their practices with respect to corporate governance and risk management systems. It's important that directors and management are required by law to fulfill their fiduciary obligations to protect policyholders' funds. The legislation before you codifies a number of new responsibilities of the board, which represent minimum standards consistent with a higher duty of care expected of financial institutions. Further, there are inadequate provisions in the law for the supervision of financial groups. Consolidated supervision of conglomerates is commonplace in most developed jurisdictions, but not here. And it facilitates the sharing of information among supervisors of financial entities in the group to ensure effective oversight of the group as a whole. Consolidated supervision requirements can be found in the legislation of many countries, including the USA, Canada, Australia, the UK, and here in the Caribbean, Jamaica, and even in the Local Financial Institutions Act, which governs the local banking sector but does not intend to extend to insurance companies. So as you can see, we clearly need to upgrade the 1980 Act as a matter of urgency. Well before the 2008 global financial crisis, the IMF World Bank Financial Sector Assessment Program missions in 2005 forewarned about the risk posed by the rapid structural changes in Trinidad and Tobago's financial system and the shortcomings in our legislative and regulatory framework. If I can quote from the 2005 IMF FSAP report, contractual savings sector has replaced banking as the single largest segment, and a few regionally active mixed activities conglomerates have become dominant. Sharp reversals in equity prices may adversely affect the insurance and pension sectors. Rising levels of connected exposure in some conglomerates have increased the risks of contagion, and that is CL Financial and CLICO in a nutshell. Given a regionally active, complex financial system, the segmentation of the core legislative, regulatory, and supervisory framework suggests the urgency of reform in these areas. Changes are required to facilitate consolidated supervision and regulation of financial institutions, including their cross-border activities. Again, we found ourselves having to deal with problems associated with CLICO and CL Financial all over the Caribbean. It's because they formed companies in virtually every country that they met in the Caribbean. And two, to transform the supervisory structure, including financial reporting, into a more integrated and risk-based framework. Critical gaps remain in the overall legal, regulatory, and supervisory structure. There's been 13 years since that IMF report, and one financial crisis later, these gaps still remain. The Insurance Bill 2016, which I'm seeking the support of honorable senators for, or for which I am seeking the support of honorable senators, will provide the regulator with the authority required to properly supervise the sector and protect the interests of policyholders. In particular, there are 7 critical aspects of this bill that I wish to share with you as follows. 1, the first critical component of the bill intends to stem excessive risk-taking and promote good governance and sound risk and capital management practices by management and boards of directors of regulated entities. For example, the CEO and CFO must now sign a statement acknowledging the board of directors and management's responsibility for A, preparing financial statements, B, maintaining adequate internal controls, C, establishing and maintaining adequate procedures for the settlement of claims, and D, complying with the prudential criteria, regulations, and guidelines issued by the central bank. In the bill, it is also mandatory to have an audit committee. The audit committee will comprise at least 3 directors, a majority of whom must be independent and must include 1 financial expert. The bill also imposes restrictions on an insurer in respect of the credit exposures that it can, directly or indirectly, incur to any person, including a borrower group, related group, connected party, or any connected group. It also requires that the board of directors of an insurer must ensure that there are policies and procedures established for transactions with connected parties and employees. 2, the second critical element of the bill seeks to ensure robust balance sheets and adequate capital buffers are held to cater for unanticipated losses. Owners or shareholders must have a stake in the outcome and have skin in the game, so to speak. Currently, there are companies doing billions of dollars in business, and they are only required, in the case of an insurance company, as indicated, to have $3 million in capital, and in the case of a general insurance company, $1 million. Now, under this bill, which I am recommending to honorable senators, insurance companies and financial holding companies will be required to hold adequate capital and adequate and appropriate forms of liquidity. Insurance companies which carry on insurance business through overseas branches will be required to maintain and hold adequate assets to support their liabilities to foreign policyholders. Because we keep getting letters in Trinidad and Tobago from countries in the Caribbean, from other governments, calling upon us, the government of Trinidad and Tobago, to use taxpayers' funds in Trinidad and Tobago to assist policyholders in other Caribbean countries who suffered from the CLICO collapse. So that now, insurance companies which carry on overseas work will be required to maintain adequate assets to support the liabilities of foreign policyholders. So no longer this will be a burden on the Trinidad and Tobago Treasury. 3, the third critical aspect of the bill will impose standards of market conduct on insurers and their salespeople in dealing with the public and give the regulator the power to revoke an insurer's registration where claims practices are found to be unfair or there are unreasonable delays in settlement. 4, the fourth critical element of the bill is the objective to expand the range of tools for preventative and prompt corrective action and triggers for intervention by the central bank. The regulator must now take intervention action when an insurer's capital ratio falls to a certain critical level. That critical level is set at 70%. This mandatory intervention action comprises giving the insurer 60 days to remedy the situation, failing which the central bank can suspend the company, or the bank can apply limits on related party transactions, require that mergers and acquisitions be first approved by the bank, there be oversight over overseas subsidiaries, and provide for minimum capital at the level of the holding company, in addition to minimum capital at the level of the insurance subsidiary, as well as consolidated financial reporting. Let me touch briefly now on the regulations, because what we did was complete and comprehensive. We did not just deal with the Act, we also dealt with regulations. The regulations to the insurance bill will help to strengthen our ability to ensure the safety and resilience of the insurance sector. Specifically, they introduce significant improvements to ensure that companies maintain adequate levels of assets, capital, and buffers to withstand risks. The regulations include regulations governing risk-based capital, by far the most important regulatory change in the bill. It will require many insurers to hold, in addition to the new minimum stated capital of 15 million, up from 3 million, additional capital commensurate with their risk profile, and will result in hundreds of millions of dollars in additional regulatory capital. So you have a situation now where the current legislation requires 3 million in capital for life insurance and 1 million for general insurance companies. With this new legislation, the capital required will increase and could increase to hundreds of millions of dollars. Every insurer will be required to maintain a regulatory capital ratio of at least 150%. This risk-based capital regime will be heavily dependent on the integrity of the insurer's actuarial reserves. An understatement of the reserves will compromise the safety and soundness of the institution, which brings me to my next point. The actuarial valuation methodology. The current legislation does not define a common approach or methodology for valuing a company's obligations, which has resulted in variations across the sector. To address this, the new legislation introduces the Caribbean policy premium methodology to harmonize the valuation of liabilities for long-term insurers. And the central bank has conducted a number of awareness and technical training sessions to fully apprise stakeholders of the requirements, and has run 5 quantitative impact assessments of the new capital regime. Additionally, there must be financial condition reports. An important element of governance and risk management is the ability to stress test its operations using various scenarios. Done properly, the process should highlight a company's vulnerabilities and the potential impact on its capital position, allowing appropriate action to be taken to limit any undue risk exposure. Our financial crisis has shown that non-traditional business activities and embedded financial guarantees can have a detrimental effect on insurance companies. Those activities would now be stress tested. The new legislation will require companies to perform a number of tests that will stress their balance sheets to determine their resilience. The financial condition report generated from these exercises will be required as a part of a company's internal risk management. Armed with information from the financial condition reports, the central bank will now have the power to direct an insurer to increase its capital in line with its risk profile. This reduces the possibility of moral hazard due to the failure of a registrant's capital to absorb losses, which, as we have seen, are then borne out of the public purse. Let me turn now to the work of the committee. In February 2017, the House of Representatives and the Senate passed resolutions establishing a joint select committee to consider and report on a bill entitled the Insurance Bill 2016 and to report on or before March 17, 2017. As I've indicated before, the committee comprised members of the government and the opposition and the independents from both houses. Cognizant of the need for transparency and consultation, the committee decided that stakeholders, including members of the public, would be invited to submit comments on the bill. It was also decided that key stakeholders, such as the Insurance Brokers Association and the Association of Trinidad and Tobago Insurance Companies, and the central bank would be engaged directly. The committee thus caused notices to be published in the daily newspapers, on the Parliament's website, and in social media in February 2017, calling on the public to submit comments. We received a number of written responses. We also received written submissions from Lloyd's of London, ATIC, IBAT, and the central bank. And based on the volume of comments, it was necessary to examine the submissions on a clause-by-clause basis. At the 4th and 5th meetings of the committee, the Association of Insurance Companies and the Association of Insurance Brokers made presentations outlining their comments and concerns regarding the bill and provided recommendations to address same. Subsequently, at our 6th meeting, the committee met with representatives of the central bank who commented on the submissions made by the insurance companies, by the insurance brokers, and by Lloyd's of London. We then took a decision as a committee to share the central bank's comments on the submissions from these stakeholders to allow those associations an opportunity to also comment on the central bank submissions. And as chairman of the committee, let me take this opportunity to thank all stakeholders and all members of the public for their submissions and their invaluable engagement on the issues surrounding the bill. I would also like to thank the Chief Parliamentary Counsel and his staff, as well as the officers of the Office of the Attorney General and the Attorney General and Legal Affairs, who were present and lent their expertise during the committee's consideration of the bill. We did a clause-by-clause review of the bill and the stakeholder submissions at our 8th, 9th, and 10th meetings. I omitted to say that we held 10 committee meetings. Following a comprehensive review of the submissions of stakeholders, as well as discussions with the supporting technical team, the committee identified several aspects of the bill requiring deeper consideration. These areas included whether the existing definitions in Clause 4 of the bill should be amended in the interest of clarity and whether new definitions should be introduced. That's in the interpretation part of the bill. Also, whether amendments to provisions concerning the fines and penalties, as well as whether offences ought to be classified as summary, hybrid, and indictable. And we did this for every single offence created by the bill. We determined whether it should be summary, hybrid, or indictable, and whether the fines and penalties were appropriate. There was considerable apprehension at the beginning among the insurance companies and insurance brokers at the severity of the fines and penalties, and we were able to reach a reasonable compromise without sacrificing the need to have strong legislation. Additionally, consequential amendments to the bill arising out of the enactment of the Tax Information United States of America Act 2017, also called the FATCA enactment, because while we were in committee between 2016, 17, and into 18, FATCA was passed by this Honourable Parliament, and therefore we had to look at the bill to see how FATCA would affect our legislation. We also looked at the ability of brokers to negotiate and procure insurance on behalf of their clients directly from foreign insurance companies, and the appropriate ratio of local and foreign assets in which insurance companies are allowed to invest. We had to be very particular about that to make sure that there was an appropriate ratio, a mix between local and foreign assets that insurance companies would hold on behalf of their policy holders. We examined again the procedure for allowing foreign adjusters to conduct business in Trinidad and Tobago, and whether there should be any strict liability offences at all in the bill. We also dealt with routine matters such as typographical and cross-referencing errors, which are not uncommon in legislation as intricate and complex as this. Let me now deal with some of the amendments made by the committee or recommended by the committee to the other place and accepted in toto and completely without adjustment by the other place. Firstly, we looked at the definitions, and we amended the definition of an annuity contract to remove all possible ambiguity. We also amended the definition of control to provide consistency with the Financial Institutions Act. Throughout this process, we had to ensure there was harmony, so we had to harmonize many provisions. Secondly, classification of offenses as summary, hybrid, or indictable. When you look through the bill, you will see that we have used all types: indictable, summary, or hybrid. I don't need to tell the lawyers in this place that hybrid offenses can be tried either way, that is either summarily or indictably, or for the laymen like myself, in the Magistrates Court or the High Court. Indictable offenses normally have higher penalties than summary offenses. Generally, offenses are made indictable because they have such exceptional gravity, or because there are other reasons such as the complexity of the issues which make them unsuitable for summary trial in a magistrate court. The trend has been to reserve indictable-only offenses for the most serious circumstances, and most new offenses in the modern era are triable either way or summarily. However, the decision as to the type of offenses which should be created ultimately falls within the Parliament's power to make policy when enacting law. We took a long time on this. We looked at each offense and determined its complexity and its severity, its gravity, and determined whether it should be summary, indictable, or hybrid. The bill contains offenses that run across the spectrum of severity and complexity. In this regard, a tiered approach was adopted in fixing the manner in which offenses will be tried. Offenses that are less in gravity can be tried summarily, while more grievous offenses will be tried indictably. Offenses in the middle were addressed using the hybrid model I just spoke about. Furthermore, certain offenses which were summary in the original form are now triable on indictment or on a hybrid basis. We felt, after reflection and getting various contributions from stakeholders and advice from the Parliamentary Council, that we should adjust the offenses and make them practical. In several instances, there was no provision in the bill regarding the manner in which some offenses will be tried. This was corrected. We also amended the bill consequent on the enactment of the FATCA legislation, and some of the amendments included allowing the central bank to share information with the Board of Inland Revenue on insurance companies, allowing the inspector of financial institutions at the central bank to issue compliance directions for breach of guidelines to give effect to the intergovernmental agreement between the government of Trinidad and Tobago and the government of the United States, allowing the central bank to issue guidelines to give effect to the tax information exchange agreement and to issue directions to persons who fail to comply with these guidelines. We also looked at the appropriate ratio of local and foreign assets in which insurance companies can invest, as I mentioned before. Now, the requirement for insurers to match liabilities with a specific percentage of local assets is historically a policy position of all governments to encourage local investment. So you always seek to limit the extent of foreign investment. It is so with the National Insurance Board as well. The maximum permissible share of foreign assets permitted by the current Act of 1980 of 20% has been the status quo for many years, and in fact, just coincidentally, that's the same ratio with the NIB. They must invest 80% of their assets in Trinidad and Tobago, and 20%, they can invest 20% overseas, and this has been the case with insurance companies. So we looked at it, and we noticed that within the regulations, the capital adequacy regulations, if insurance companies were seeking to hold assets overseas, they were required to hold additional capital against the foreign exchange mismatch and other risks. As such, we amended the original legislation to allow the percentage of foreign assets in which an insurer can invest to be increased from 20% to 30%. But of course, they're now required to hold additional capital as a buffer against the risk of holding assets in a foreign jurisdiction. Also, the liabilities for policy, where the liabilities for policy are payable in a foreign currency, the insurer must now invest in foreign assets in that currency, an amount of at least 70% of the foreign currency liability. Additionally, we looked at the question of strict liability offenses. Formerly, Clause 254(2) provided that where a person contravene any provision of the bill or a direction, requirement, or measure of the central bank, its board or the inspector, he or she, committed an offense. This clause did not make express provision for a requirement of intent, mens rea, or recklessness concerning the commission of the offense. The committee therefore amended or recommended amendment to the other place, which accepted it, that clause 254(2) be amended to provide that this offense occurs where the person acts knowingly or recklessly. Now, Madam President, as I said, this bill has over 200 clauses. The Honorable Senator Mark told me it has 282. This has been, I believe him in that case. Yes, I believe him in that case. I wish to play, I trust his arithmetic in that matter. I wish to place on record my absolute gratitude to all of the members of Parliament who serve with me on the Joint Select Committee. And if I risk abuse from my own members, I wish to pay special mention to the members of the opposition and the independents who serve with me on the committee. They were very supportive, very helpful, very collaborative, and very cooperative. The active interest of all members of Parliament, whether from this place or the other place, their interest, their interrogation, their analysis, their contribution, their attendance in the meetings have resulted in what I believe to be a refined piece of legislation, which I feel confident and I hope that this House will support as the other place supported unanimously. In conclusion, I wish to emphasize that this bill has been influenced by international best practice. Sure.
I don't know if you're aware, you ought to be, that regulations in draft form are now controlled by the Board of Inland Revenue for purposes of registering all pension plans in Trinidad and Tobago. I wanted to ask you, are those regulations going to be transferred into this piece of legislation, saying that the new agency that is responsible for registering all pension plans in Trinidad and Tobago will now be the central bank? So therefore, the accompanying regulations should also find their way here. So I'm just seeking clarification as to where are those regulations as it relates to where it currently exists at the Board of Inland Revenue. Are we transferring them to this piece of legislation? Just trying to get some clarification from the Honourable Minister.
I can assure you, Honourable Senator, before the debate concludes, we will deal with that. I will seek clarification from the legal advisors to the back of us there. As I was saying, this bill has been influenced by international best practice, and we hired international consultants as well. The Parliament engaged international consultants to assist us with this legislation. It's the product of a very exhaustive and very robust consultative process. I believe that our own crisis, our own CLICO crisis, as well as other stresses in other insurance companies in our local industry, convinced everyone of the need for modern legislation to cope with a modern financial sector. I don't think I need to say that we can no longer work with 40-year-old legislation with capital requirements of $3 million and $1 million. Those are hopelessly outdated. So with this bill, we are seeking to correct all of the errors and deficiencies of
Minister,
the past.
you have 5 more minutes.
Yeah, I'm nearly finished. And I simply want again to read into the record the committee members, Mr. Al-Rawi, myself, Ms. MacDonald, Mr. Lee, Dr. Rambachan, Mr. Rambarat, Mr. Duki, Dr. Henry, Mr. Sturge, Mr. Kreese, and Ms. Raful. We also were very ably assisted by Mr. LaRoche and Ms. Yallery. And permit me to correct an omission of mine, Mr. Hines, who at one point in time in his history sold insurance, believe it or not, was also a member of the committee. Pardon? Yes, and later on, Senator Ramdeen replaced Mr. Sturge, I believe. And again, Senator Ramdeen's contribution was invaluable. So I'd like to thank everyone who participated. This was truly, for me, a success, a very heartwarming experience. And I commend this bill to the Senate, and I beg to move, Madam President.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Repeal and Replace the Insurance Act, Chapter 8401, to reform the law relating to insurance companies, to regulate insurance businesses and privately administered pension fund plans, and for other related purposes, be now read a second time. Senator Mark.
Thank you, Madam President, we too would like to join the Minister in recognizing the work that was done by the Joint Select Committee on this very important piece of legislation. We are way behind, I must admit, as he has identified. The world has gone way ahead of us. 1980. That's the last time we amended and brought modern legislation to our Parliament. So you're talking about, Madam President, about close to about, almost 40 years, 38 years. And it took a global financial meltdown or crisis, coupled or combined with the CLICO debacle, to shake up this society into recognizing the need for modern legislation. But I'm glad that the Honorable Acting Prime Minister is still here, because I want to put some suggestions even before I go into the meat of our contribution today. Okay. Madam President, we cannot be passing legislation and not putting a clause in a legislation as important as this one for review. We should have a provision in the law that commands the Parliament, Madam President, to review the legislation within every 3 to 5 years. Because as we have all recognized, Madam President, the world is moving at a rapid and dizzying pace. And even though we are dealing with this legislation today, Madam President, there are many changes that have occurred since then. And we are not the wiser because the legislation that we have before us certainly has become dated even as we begin this debate in the Senate to update this piece of legislation. So, Madam President, as I said, it was the global financial crisis that laid the basis for this country's recognition of the need for legislation. But more importantly, the matter involving CL Financial, CLICO, and the CLICO Investment Bank really push the process forward. There are many issues I would like to address in this piece of legislation that is before us and the report that is before us. Madam President, we know that the bill before us provides for the regulation of the industry, that is the insurance industry. But it is part of the financial services sector, which, as you know, contribute between 15 and 16% of this country's GDP. It deals not only with insurance companies, but very curiously, Madam President, with pension plans. I find that a bit unusual. And this is one of the areas that we have some concern about. Even though the Joint Select Committee might have incorporated both. The question here, why are we confusing pensions with insurance? And Madam President, out of 282 clauses, only 13 clauses are devoted to pensions. And pensions, as we were told by the minister, constitute an industry valued at close to $100 billion. The insurance industry assets could be between 25 to 30 billion. So the pension industry is way above the insurance industry. And why, Madam President, in 2018, are we placing pensions in the same legislative framework as insurance? That pension, Madam President, ought to be a standalone piece of legislation. Occupational pension plans ought to constitute a separate and distinct piece of legislation. And that is why I have some concerns about that provision in the legislation, which I will develop on as I proceed. So, Madam President, we are talking about protecting the consumer, the policyholders, that is, who access insurance policies in this country. We know that a lot of citizens have been defrauded by insurance companies in this country. And that is a matter that remains of grave concern to citizens of this country. And we will talk about that a little bit later, Madam President. So the legislation that is before us, manifested in this Joint Select Committee's report, is looking at the whole issue of compliance enforcement, and the agency that is now responsible for enforcement and compliance and regulation of this particular insurance industry. And now we have now added pensions administration onto this particular agency or institution, which is the central bank. So the Central Bank of the Republic of Trinidad and Tobago is now given the responsibility, Madam President, not only for financial services as it relates to banks, but they are now responsible for insurance companies, and they are now responsible for pension plans. And as if that were not enough, shortly to arrive on this compound is legislation for the credit union industry, which we understand, Madam President, is also going to be administered and controlled by the central bank. So that begs the question, is the central bank ready? Does the central bank have the resources? Does the central bank have the technical capacity and ability and wherewithal and skills sets in order to deal, Madam President, with this particular new responsibility that they are being given? These are matters that we would like to know, we'd like to get clarification on. Because the central bank, as you know, has become a bit weak over the years. And maybe with all this new power being given the central bank, Madam President, it really begs the question whether we should not be bringing legislation to this Parliament to strengthen the central bank of the Republic of Trinidad and Tobago and making the central bank more independent of the executive and the Minister of Finance. That is what we should be asking also, because the central bank is given a lot of power and a lot of responsibilities, Madam President. Not only do they have preventive or preventative intervention, but they also can take corrective intervention measures. And the role of the inspector, Madam President, in the legislation that is before us in this report shows that the inspector of bank is a very powerful agency and office holder within the framework of the central bank. And I can understand why, Madam President. That central bank inspector has power, authority, and he's given responsibility and accountability because he has been given power and he has been given authority, and therefore concomitant with that must go responsibility and accountability. The question that has to be asked, Madam President, and maybe the Minister in the Ministry of Finance or the Attorney General can tell us, give us an organogram, give us an appreciation this evening of the composition of the Inspector of Banks Department or Division as we speak today, having regard to the work and the responsibilities being given to the Inspector of Banks. And we understand it took a long time before the governor of the central bank and the Minister of Finance took a decision to appoint a governor of the Inspector of Banks. But we are happy that one has been ultimately appointed. So what we need to clarify, Madam President, who are the people in this division or unit that make up this Inspector of Banks? Because you need skill sets. You need qualified people in order to monitor these insurance companies. and to monitor pension plans in Trinidad and Tobago. So we need to know how many actuaries they have in that bank, as an example. So could the minister in the Ministry of Finance or the Attorney General, when they are speaking, bring this Parliament up to speed with the wherewithal in terms of the personnel that would make up that inspectorate within the central bank? So we would be aware, Madam President, that when we approve legislation, that we will never be able to have a repetition of CL Financial, Clico, Hindu Credit Union, ever in the Republic of Trinidad and Tobago again. So we need answers. We know we want answers from the government as we press forward with this piece of legislation, Madam President. Madam President, you and I are aware that within the central bank that is governing this insurance bill, which is going to become an act before we leave here this evening, that act, Madam President, when it is translated and is operationalized, Madam President, is going to be managed, as I said, and administered by the central bank. But the question that has to be asked, Madam President, is this. We are dealing with legislation to strengthen the Insurance Act of 1980, and we have it before us. But I would like to ask the Attorney General, through your good self, given the Coolman's Commission of Inquiry, our Prime Minister came to this House, that is the House of Representatives, made a statement in July of last year, saying that he is sending the report to the DPP. And the DPP will write us back to determine whether it can be published fully or partially. That is according to the Prime Minister. We are now almost 10.5 months after that statement was made, and we are none the wiser, Madam President. Has the DPP written to the government? Has the DPP said this report cannot be made public, partially or fully? And Madam President, may I advise and remind you, several sections of that report, when the Prime Minister read his statement into the records of Parliament, dealt with the insurance industry. So again, the Attorney General must advise this House whether we are dealing with legislation today that ought to have been strengthened as a result of the Coolman's recommendation. These are things that I would like to have clarified. I hope you don't take my time, because you know my time is very limited. So once you rise, I'm in trouble. So, Madam President, I'll ask him to take notes at this time, and he will respond to me at the appropriate time. I can't afford a minute. I need more time, Madam President, as you know. I need more time, not less. So, Madam President, as you know, I am asking the Honorable Attorney General these are red flags that I'm erecting that I want answers to, Madam President, and the country would need answers to. Because we know, Madam President, that there are many things that are hidden in that Coolman report. Coleman report. Well, the report gone cold. That report has gone cold. We haven't heard anything about it, Madam President, since then. So, Madam President, I hope that the Attorney General will tell us what is happening with this report and all the criminals who have defrauded this country, right? That action is being taken against them by the DPP. We hope that, for instance, that is being done as well, and that we are not covering up, anyone is not covering up this report, Madam President. And I'm not saying anybody's doing that. I'm saying I hope nothing like that is taking place. Madam President, you and I would be aware of the kind of challenges that consumers face in this country when they take out insurance policies, whether it's motor, life, Madam President, health. It does not matter what is the nature of the policy that you take out. There are challenges faced by the population. And many citizens are subjected to all kinds of misbehaviors by these insurance companies in Trinidad and Tobago. And Madam President, at the central bank, we have what is called a financial ombudsman. And that ombudsman is supposed to deal not only with banking services in terms of if you're having challenges, but also insurance services. And now we are strengthening the Insurance Act through this report. What is the role of the ombudsman? Should the financial ombudsman, Madam President, remain a creature of the governor of the central bank? Should the ombudsman remain literally, Madam President, an employee of the governor of the central bank? How can the ombudsman, the financial ombudsman, render independent, objective services to customers, policyholders who approach that ombudsman for assistance and help, Madam President? You remember, Madam President, the central bank is regulating the industry. The central bank is administering the legislation. And the central bank has a financial ombudsman that it employs. So, Madam President, isn't that a bit contradictory? Isn't that, as I would call it, a conundrum here? Why would we want to have an ombudsman, a financial ombudsman, who is supposed to give services to customers, policyholders who are aggrieved by activities and actions and decisions taken by insurance companies and commercial banks? And that very company, Madam, that very ombudsman is under the control of the governor of the central bank. So therefore, I am proposing for the government's consideration that that financial ombudsman should stand alone. That financial ombudsman should become an independent office holder and should not be beholden, Madam President, to the governor of the central bank. Because we are not seeing, we will not get the customers of this country, the consumers of this country, the policy holders of this country will not be able to get the kind of justice if you have somebody reporting, Madam President, is himself reporting to himself. That cannot be fair. And something has to be wrong with that arrangement. And I cannot support a report blindly. So I am asking the government to look at some of these measures to strengthen this legislation. Make the ombudsman, the financial ombudsman, independent of the governor of the central bank, so he or she can take action on his own in the interest of the consumers, Madam President. Madam President, I am seeing in the legislation where the committees debarring, and I have no problem with that, banks, insurance companies from engaging in banking, which is good. You stay within your zone. But I don't believe that banks are debarred from engaging in insurance matters. So isn't that a contradiction? Why are banks allowed to embark and engage in insurance matters and it is legally allowed by the act and the laws of our country, Madam President. But on the other hand, the government is bringing legislation to debar insurance companies from taking part in banking activities. And I'm saying I agree with the Attorney General and the government. Let these companies stay within their zones. But tell me what gives the banks of this country, Madam President, who are reaping and creating havoc for many ordinary citizens of this country because of how they treat us and the returns that we get on our savings with them, and they're having a field day. Why must they be allowed to be involved in insurance? Well, I can tell you they are. You may not be aware, but they are. So, Madam President, that's another area we call on the government to examine very, very seriously. Now, Madam President, you see this place they call the Parliament? You know, I am very passionate about it. Do not take me and take us for granted. We are not rubber stamp. We are passing laws, Madam President, to give to the central bank power to regulate the insurance industry and to regulate, Madam President, pension plans. In the legislation, they are supposed to submit annual reports to the Minister of Finance. But that's the end of the matter. Those reports must be tabled in the Parliament. And those reports must be sent to the relevant Joint Select Committee for inquiry and investigation. But I don't know if I didn't see it. Maybe the Attorney General can point out to me where in the legislation these reports are coming that the Minister of Finance will be in receipt of to the Parliament of the Republic. So you're asking me to give you power so that the central bank can have all this control, which I have no problem with. But who is going to guard the guard? You remember the central bank, Madam President? There was a former governor of the central bank of this country who is now an advisor to a minister in this country. And he was one of the first customers at the doors of the Clico Investment Bank when they heard that a run was about to take place. And that was the gentleman who was supposed to be supervising the bank. He went to take out the money first. So, Madam President, I'm asking the question, who will guard the guard? Who will guard the guard? The central bank, yes, they are independent, but we want them to be more independent of the government and the minister. Sometimes you can't make a distinction between the governor at the central bank and the Minister of Finance. You want to know who is the real governor of the central bank. The relationship is so incestuous. So, Madam President, we are advising the Minister and the Attorney General and the Minister in the Ministry of Finance to do something about this question, Madam President. You cannot have a bank self-evaluating itself. Somebody must do that for it. And, Madam President, who is best placed to do so but us in the Parliament? We must supervise that bank. When I say supervise, we must be responsible for bringing that bank here based on its reports that it must submit to this Parliament, because we are the ones who are passing the law and we are giving you power. Therefore, you must be accountable to the Parliament, Madam President. Madam President, you go to clause 10 on page 245, right? A major duty of the inspector, right, of the central bank is to approve. It is our view that a major duty of that inspector of bank should be, Madam President, to approve all products sold by insurance companies. All products and services provided by insurance companies in the Republic of Trinidad and Tobago must be approved by the central bank through the inspector of banks. Madam President, you know the experiences we have had as customers in this country, as policyholders. We buy cat in bag, Madam President, and before you know it, they bankrupt you. And all your money go up in smoke in this country. How are we going to regulate, Madam President, these products, these insurance companies who devise products and provide services, Madam President? Somebody must approve those things. Who is going to protect us? So this is a matter that we need to pay some attention to. Madam President, you know there's a product called derivative, right? And I saw no mention of it in the legislation. And that was one of the products that caused the meltdown in many of those countries when we had the financial crisis. And I don't know if it's an oversight. No, I'm saying that in the report, in other words, can insurance companies be engaged in that aspect? The development of derivatives. Madam President, I'm not going to engage. Well, Madam President, remind me, are we going into committee? Clause by clause? Or are we just going to adopt the report? Just remind me again. All right, so we will go in committee. So when I reach here, I'll advise you, sir. Madam President, so that is an area that we would like the government to pay attention to. And Madam President, when I talked about the matter of the ombudsman, that ombudsman will be responsible for dealing with malpractice in terms of products and services that are issued by these insurance companies, Madam President. Madam President, I want to take you to this section that deals with pension. Pension is in clause, starts from clause 216 of the bill, Madam President, and it ends, I think, at clause 229. Madam President, I asked the Honorable Acting Prime Minister, and I'll ask the Honorable Attorney General, so when he's speaking, he can guide us on this matter. Are the draft pension regulations of 1969, which are used by the Board of Inland Revenue to register pension plans in the Republic of Trinidad and Tobago, and there are over 182 pension plans in the Republic of Trinidad and Tobago. Madam President, are those regulations going to be inserted in this bill? Or will those regulations remain with the Board of Inland Revenue? But since the Board of Inland Revenue will no longer be registering, Madam President, pension plans, then why would the regulations remain with the Board of Inland Revenue? So it has to go to the central bank. But I have looked through, Madam President, this 296 pages of material. No, 400, Madam President, what am I saying? Madam President, 485 pages. And I haven't seen those regulations. So, might I ask the Attorney General to tell us, where are those regulations? And Madam President, would you believe, from 1969 to the present time, which is almost 50 years, we are governed by draft. Senator Roach, draft regulations. It was never signed in 1969 by the Governor General of the country. That is what I understand, and maybe the Attorney General can tell me if those regulations are in draft or are they substantive. Have they been properly passed? Have they been signed and assented to in 1969 by the then Governor General? But you know, Madam President, what is sad about it? Madam President, I raised this question about pensions because of former trade unionists. I understand the significance and the importance of pensions for workers. It's a savings that workers embark upon when they begin to work and they save their monies. The employer contributes a portion and we contribute a portion, Madam President. And it is invested, and they have trustees of the plan and the pension fund, or plan as the case may be. Madam President, you know, in the draft regulations, the Board of Inland Revenue has stipulated anyone who submits a plan to the Board of Inland Revenue to be registered as a pension plan, everyone is told there is a line in the sand that you cannot cross. That line is in the sand marked 2/3. I don't know where that came from. You have an illegal set of regulations in the first instance. Never became law. But the Board of Inland Revenue has taken it upon itself, Madam President, to tell you that you cannot get more than 2/3 of your retirement funds as pension. Why not 90%?
Senator Mark, you have 5 more minutes.
Madam President, thank you. Madam President, you and I, if we want, when we retire, Madam President, if we want to get 100% of our pension, why can't we take 100% of our pensions? If we want to take 90%, why can't we take 90%? If you want to take 80%, Madam President, it is our money. It is we who saved it. And the employer pays a certain portion in accordance with law. It is only if you're a public officer you get 100% contribution from the government. Other than that, you pay and you make a contribution, 2/3, 1/3. But the Board of Inland Revenue tells you that you can only go with 2/3. Why is that so? Who gives them the power to tell a trade union or a group of workers who are involved in a pension plan they can only take 2/3? This is something that the Attorney General needs to address, because you have to give the workers the flexibility. So if they want to go, as Ken Valley, may his soul rest in peace, he was saying that they were going to amend the laws and create an occupational pension plan. And under that pension plan, he was proposing 80 to 85%, where the worker can go with 80 to 85% of his pension home and take another 15% in gratuity. But we are told 2/3, 1/3. Why is that? So, Madam President, you see, ma'am, why I told you I needed that more time. I have now begun to wax warm. And I have so many other things, but time rushes on. So I have to take my seat in a few seconds, I would imagine. So, Madam President, I also would like to ask the Honorable Attorney General that he should consider, in the workers' interests, to repeal all provisions relating to the harmonization of occupational pensions with NIS pensions, since such harmonization results in a reduction of pension income. That is a setback for workers. And I also would like to ask the Minister in the Ministry of Finance, can you tell this Parliament, I looked at the Guyanese Insurance Act, which was passed in 2016, and there's not a single mention of pensions in that insurance bill, which is now an act. You know why? Because Guyana has its own occupational pensions plan in the country. So there's one pension plan in the country. Why it is, Madam President, we cannot get that occupational pension plan going for the workers of Trinidad and Tobago and for the people of this country? Can the Attorney General give this Parliament an undertaking that within 3 years or less, because you will be out and we'll be in, so we'll have to do it for you. But at least let us give the workers an undertaking that within a short period of time, we will have an occupational pensions plan standalone and not being part of an insurance bill now to become an insurance act. We need that independent plan for workers in terms of occupational pension plan. Madam President, I know my time is up. There are some areas I would like to ask the Attorney General to consider, and this is the last one. Attorney General, through the Honorable President, please consider an amendment to the law that will place into the legislation a provision, Madam President, or a clause to review the legislation within a 5-year cycle or 3 to 5 year cycle, so that we do not have a repetition of 1980 coming at us again. 1980, and 38 years later, because of a crisis, we are reacting, Madam President, in 2009 and the clinical debacle. Let us think in advance. Thank you very much, Madam President, for the time you have allowed me to make my contribution. Thank you very much, Madam President.
Senator Mahabir.
Thank you very much, Madam President. Madam President, I rise to give full support to the government to this piece of legislation. Madam President, there is a lot of commendations which must be delivered this evening. As a member of the Joint Select Committee in the 10th Parliament, together with the Honorable Attorney General then and the current Minister of Finance, we worked assiduously and tirelessly, and this bill has lapsed on a number of occasions. And I can assure you, Madam President, that for the first time, I am able to say there is a piece of legislation in which I see absolutely no political mischief in any of the clauses. This is purely technical. It is meant to ensure that a critical industry operates under rules. And I myself was a bit concerned that this particular Parliament, this 11th Parliament, will come to a close and we will not pass this law. And I'm hoping that I'll be able to persuade the Senate as well. I'm not advocating for the government, but I'm hoping that we will be able, by the end of today's sitting, that we will pass this law and finally get the insurance bill into act. Madam President, well, yes, because, Madam President, you see, the iterations which have gone through and the level of detail which was involved, the amount of consultants that we engaged, and the inputs of all the stakeholders domestically, the insurance companies, the central bank, and technical experts, ensured in my mind that we have today what is perhaps the best position on the matter as of this time. There is, of course, no perfect legislation because industries continue to evolve, and the law usually is a few steps behind a regulatory law, and I speak as an old regulator myself, as a former chairman of the Public Utilities Commission, and Senator Mark, of course, is right. We do need to review the legislation periodically. I am just wondering whether it should be via legislation or whether it should not be the regulator himself, in this case a central bank. I will come to that. when I am closer to my conclusion, I'm wondering whether it is not the duty of the regulator himself, to alert the relevant line minister that there may be a few clauses that we need to change based on developments over the last few years, and we subject the legislation to that type of review. Madam President, the former Minister of Finance, Mr. Larry Hawaii, was also a key architect. The former government was critical. The former independent bench played a role. And so I think this is the joint select committee system at its best in the Parliament of Trinidad and Tobago, and it shows what we can do to ensure that the public interest is defended. Madam President, those are the preliminaries. I only have a concern with one clause, and I am proposing absolutely no amendments. The time for amendments has gone. I think all of those matters ought to have been raised and settled at the Joint Select Committee system. This bill was available to all of us, and if we had concerns, I am sure we could have raised them through our relevant members to ensure that they were sorted out and settled at the committee system before it reached this particular state. But, Madam President, with your leave, I will have, as reluctant as I am, to discuss a few technical matters. And my colleague, Senator Roach, has chastised me on a few occasions for getting much too technical on matters of public interest. But the insurance bill is, in fact, very involved and very technical. And we need to ask ourselves a simple question. And the question, Madam President, is this: why is there a need to regulate the insurance business? We have always known of the need to regulate banking. The difference between banking and insurance is simple. Banking deals with really short-term financial arrangements, and insurance with longer-term instruments. There is a critical time dimensions. Banks deal also with risk of a different financial sort. Insurance really are supposed to specialize in risk management. But why regulate insurance? We know that we regulate banks because banks cannot function without proper rules and regulations, since there is something known as systemic risk. One bank failure can cause the society to lose confidence in the banking system, and then they can withdraw their deposits, causing a run on the bank. The deposits can be placed in your safes at home, and in that way, we become our own private bankers. When that happens, the financial economy is compromised, credit is reduced, and there is chaos in the financial economy. But is there that type of systemic risk with respect to insurance companies? And so, Madam President, we need to look at how this bill came to be what it is today. Does it have its genesis in the financial crisis of 2007-2008? Or is it a little bit different? And we also need to consider, Madam President, that we are speaking about one insurance company. That's a Colonial Life company and its affiliates. But we need to understand that there are many more insurance companies in Trinidad and Tobago which were not really subject to the kinds of difficulties experienced by a Colonial Life. So it had to be many insurance companies in the country who were actually conducting their affairs prudently. They were doing what they have done traditionally well, and they were regulating themselves. They were operating under their own industry codes. And on that point, Madam President, as an aside, I agree with Senator Mark. While the legislation before us is meant to regulate insurance companies in general on how they conduct their affairs so that there is going to be no stress to the government in the future, and that they are not going to find themselves in the kinds of crisis that we saw with Colonial Life and its affiliates, it is important for us to understand that legislation must result in benefits to the ordinary people. And I concur completely with Senator Mark that when the central bank comes to regulate insurance in a more meaningful way, I know it has an inspector of insurance, but when it comes to regulate insurance in a more meaningful way, we would want the central bank to defend the interest of the small individuals in society, small, Madam President, individuals who have small claims maybe less than 25,000. And we know that insurance companies have traditionally, in many instances, paid their claims, but in some instances we know that they unnecessarily delay the claims owed to the population for smaller sums, hoping maybe that these claims will somehow disappear and they can frustrate the claimants. My hope is that we, in the regulatory arm of the state, the inspector of insurance and the part of the central bank that deals with the regulation will, of course, have standards of service so that the poorer people in Trinidad and Tobago, not necessarily the poorer people, but someone with small claims, instead of hiring legal attorney, which will consume his claims in any event, can simply call the inspector of insurance and indicate, I am having this problem, can you assist to sort it out for me? And central banks, Madam President, have this power known as moral suasion. That is, they don't need to take any action except a phone call to indicate, we understand that you are delaying on this claim for this individual. It's now 90 days old. Could you comply within, say, a 30-day period? So that's aside, and that's to benefit the poor people. And I'm hoping that this particular legislation will allow us to do that. But, Madam President, I ask myself, and I will come to only one clause, and I will not, as I said, seek any amendment, but I ask myself, Madam President, whether this particular piece of legislation by itself will ensure that a replication of the CLICO crisis does not reoccur sometimes in the future. And I am not convinced that the legislation, as necessary as it is, alone will do the job for the people of Trinidad and Tobago. And so, Madam President, I want briefly to speak about two instruments shortly, and then a third concept. And I assure you, I will pull them together. One is a derivative instrument alluded to by Senator Mark. That is known as the credit default swap. What is a credit default swap, Madam President, and what does it have to do with what we are doing? The credit default swap is a simple instrument. It is something that is lacking in contention. Basically, it's as follows. General Electric decides to raise some money, $100 million, and it floats a bond, 5% for 10 years. Someone buys the bond. So he holds a GE bond for $100 million, 10 years. He collects $5 million every year in interest. But he has this fear that maybe GE might default. GE is a Dow component. Hardly likely, but he's not sleeping too well at night. So he asked an insurance company called American Insurance Group, AIG.FP, Financial Products. Real example, no hypothetical there. And AIG says, not to worry, pension fund, not to worry, investor. I will insure this $100 million bond for you. And you just pay me a premium of $1 million a year. And if GE defaults, I will give you back the $100 million. AIG had a good business doing this because in the S&P 500, you had S&P 500 companies assessed by Standard & Poor's. The chance of anyone defaulting is so low that anyone who wanted to buy insurance on their bonds, AIG is very happy to sell it. And they made a large amount doing that. This is the seeds of the financial crisis, 2007. But you see, Madam President, a credit default swap is different from another instrument called the collateralized debt obligation. They look the same, they smell the same, but they are as different could be. What is this collateralized mortgage obligation, collateralized debt obligation? Where am I going, Madam President? I am going to link that to what is happening with CLICO and with the legislation before us, which is looking at the crisis of 2007, and we want to avert that. But I am seeing something else with the CLICO that I would want to raise with the Attorney General for his consideration. I myself have not seen the report of the Commission, but I would raise it for the AG for his consideration, of course. What is this collateralized debt obligation? This is it, Madam President. Instead of a 100 million bond from GE, suppose there are 100 mortgages, each with $1 million. You add them together and someone buys the mortgage, all 100 mortgages, and he now owns $100 million in mortgages. He packages it into a $100 million bond. It is a mortgage-backed security. And then he takes this $100 million bond, and the mortgage is at a 5% rate, looks like a GE bond, and he goes to AIGFB, and he says, AIGFB, I have this security, this mortgage-backed security. It's a collateralized mortgage obligation. Could you insure it too? And what does AIG do? AIG, Madam President, has had the largest bailout in the history of this planet, $85 billion from the US government. What does AIG do? AIG says, well, I really don't know what is this CMO collateralized. It looks like the mortgage default. Let me check and see what Standard & Poor's and Moody's has to say about it. And Madam President, this is where the problem arose. Standard & Poor's and Moody's can rate certain things, but insurance companies are supposed to assess risk. If the insurance company takes a rating from Moody's on these 100 mortgages, and Moody's says they were good, AAA, AIG says, fine, I will insure this 100 million mortgage-backed security for you for the same $1 million a year. Look at what is happening, Madam President. For $1 million a year, AIG said, I will insure the mortgages for you, and if the mortgage holders don't honor their obligations, I will give you back your $100 million. Well, Madam President, look at trouble. All those mortgage holders, $1 million each, started to default one after the other. Like all kind of mortgages inside there. You see, a lot of problems occurred there. And the problem was micro in nature. And AIG found itself holding all of these non-performing mortgages. So, Madam President, we see the seeds of the crisis when not only AIG insured the mortgages, but Deutsche Bank and all of those Lehman Brothers started to buy these collateralized mortgage obligations created, these are the derivative securities alluded to by Senator Mark, created by Wall Street, packaged and sold across the world. We got international transmissions of the risk, the meltdown. The problem, Madam President, is this. The AIG and the Munich Re and all of those General Reinsurance and so on did not know the risk they were handling, which is surprising because an insurance company is supposed to master risk. How could it just pass on to Standard & Poor's risk assessment? And how could it simply say, for a $1 million, I will pay you your $100 million if it defaults without checking? The seeds of the crisis, Madam President, led to chaos in the US economy and elsewhere. But, Madam President, was that the cause for CLICO getting into trouble? When I looked at the CLICO issue, and so we do need to take into account these types of practices which can place insurance companies in serious trouble because, Madam President, we need our insurance sector to be strong. I will come to that. For me, the CLICO crisis was not really related to what happened in 2007, because I recall a former minister in the Ministry of Finance in the Pandey administration, Trevor Sudama, somewhere in 1998, saying that he had serious concerns with the ability of CLICO to honor its obligations. I understand he was chastised severely and so on, but that problem arose since 1998, a good 10 years before the crisis of 0708. So we have had here a company, and at the same time, Madam President, we have had insurance companies who had no such issues, save and except sometimes the reluctance to pay a little claim here and there. And I know we will get to that. So the CLICO issue is, in my mind, separate and distinct from the financial crisis of these mortgage-backed securities, these collateralized debt obligations. It was not that which caused them. When we look at the evidence, what we saw was that CLICO was operating like a bank with short-term obligations, investing like an insurance company in long-term instruments, including things like gas processing facilities for methanol and so on. And the mismatch, bad investments were really causing a problem with cash flow. And we had then a situation where depositors had to be paid because of the high interest rates on their deposits out of new deposits, giving rise to a classic Ponzi scheme arrangement. It is here, Madam President, that I want to raise for the consideration of the Honorable Attorney General, who incidentally worked very hard. We worked very hard in the 10th Parliament to get the law to a particular point. And that is this notion of fiduciary responsibility. We don't speak about it too much in Trinidad and Tobago, but what is fiduciary responsibility? The fiduciary responsibility really refers, Madam President, to the need for those who are entrusted with people's money, either banks, insurance companies, or non-bank financial intermediaries, to behave in a manner so that the trust will be preserved. And if errors are made, the errors are really going to be errors based upon uncertainty. What it says is that once funds are entrusted to you, you are not going to act in a reckless manner without due regard. You are going to ensure that the funds are invested properly and with normal risks. You are not going to simply take these funds because they don't belong to you and invest in them in assets that you don't understand. Invest in them without due diligence, and the consequences are going to be borne not by you, but the consequences are going to be borne by the population of Trinidad and Tobago. And I think we need, Madam President, to look at fiduciary responsibilities now very carefully. Reason is, we have seen it in the early 1980s with International Trust. We saw it with the Hindu Credit Union and with the Colonial Life fiasco, and it's likely that we will see it over and over again. And it is possible that the DPP may be looking at the report to see whether certain SEC, Securities and Exchange provisions have been violated. But, Madam President, I looked at some laws around the world, and while the violation of fiduciary responsibility is usually of a civil nature, that we could initiate civil action against those who mismanage and misuse our funds, the problem arises when individuals who have misused your funds have themselves become bankrupt. So they have misused their funds and they have lost the money and there is nothing for you to claim on. Well, in the state of Texas, there is the criminalization. I read the law, it is 3245 C and D, in a classic case of Holt versus the state. Mr. Holt had violated fiduciary responsibility, fiduciary duties, and he was given 23 years in jail based upon the Texas Code. When he appealed to the Texas Appeal Court in Holt versus the state, the appeal court ruled that 23 years for taking people's money and really gambling it at a roulette machine was not cruel and unusual punishment, as Holt alleged, but rather to be expected because Mr. Holt apparently had misused the funds of elderly people. And they looked very much askance, Madam President, in the state of Texas to criminalizing. So even though you could initiate civil action against the individuals who misuse your funds, I think we could look at criminalizing as well. The reason, Madam President, is this. What concerns me, we have spent $30 million. We approved $30 million a couple of days ago for the CLECO report. And my fear is, unless we criminalize this type of activity, we are going, independent of the good legislation before us, we are going, Madam President, to see time and time again individuals coming, knowing that there are no criminal sanctions against them, thinking that the state once again, because it is elderly people, you see this issue of savings, the majority of people who have money, who invested in CLECO are people who are retired or close to retired. The majority of people who invested in the trust companies in the 80s were retirees. And we need to understand now that these are individuals who have reposed their trust on these individuals, and there must be some penalty once the trust is violated. In the banks, we have fit and proper guidelines. We will need to do the same, Madam President. I leave this for the Honorable Attorney General, who in any event is much more learned in insurance than I am. But I think as a society, we need to be looking at criminalizing this violation of the fiduciary responsibilities to send a clear signal that what happened in the past was past, and in the future, $20 billion will not have to be handed over to the people from the Treasury because the Treasury needs every single dollar it can get. Madam President, let me focus on, and so that's my first recommendation. Let us look at criminalizing the violation of fiduciary. It is happening too often in Trinidad and Tobago. Insurance, Madam President, is all about risk. And I think we do need to ensure that we manage risks very well. We need a strong insurance sector in an economy. An economy cannot function efficiently without insurance. Why? Because risks, Madam President, act like sand or contaminants in the oil of an engine. When the engine has impurities, it can cause the car to stall or malfunction. The insurance company acts as the filter. The oil passes through the filter, the grit is removed, and the engine can run. And Madam President, Caribbean societies, as we know them now, had their start because of the influence of Lloyd's of London. Lloyd's insured the human cargo, but it was cargo. Lloyd insured everything from the Caribbean going up so that there were people who got into the business knowing that there was an insurer just in case there is some kind of calamity, we will be compensated. And insurance operates on randomness, the law of large numbers, the fact that events are not correlated. In the mortgage crisis of 2007, the mortgages were all correlated because, Madam President, subprime simply means that you don't qualify for the loan. It's just a big name. You don't qualify for the loan because you don't have the financial stability to take a mortgage for the next 20 years, but no worry, we will give you the money, knowing that we could sell this loan to somebody outside there, and it is really one of those things that we need to be looking at. But, Madam President, when we look at insurance and we look at risk, we know that they deal with long-term obligations. Banks, as we say, deal with short-term. And it is in this context I need to focus on Clause 85, only Clause 85. And it says in Clause 85 that I recall raising this as well in the last Parliament. An insurer shall invest in assets in Trinidad and Tobago an amount equal to at least 75 to 70% of its policy benefits liabilities. So when I saw the investments and the restrictions on investments to assets in Trinidad and Tobago on an amount equal to at least 70% of its policy benefit liabilities, I agreed with Senator Mark that we do need to review the legislation periodically. My only issue was whether it has to be via the law or whether we leave it up to the regulator in consultation with the industry stakeholders to determine whether changes should not be made over time. I am a bit reluctant to put anything like that in the law, Madam President, as of now, because this is what we now need to do. Insurance regulation is relatively new. The United Kingdom has some expertise. Our central bank will have to develop the expertise. Before this act is proclaimed, the central bank will have to ensure that it has its regulators in place, its team of experts, individuals who are very well trained with all clauses in this particular piece of legislation and who will be able to enforce the law. That, I think, will take time. I am hoping it is not going to take a inordinately long period of time. In fact, it is my hope that the central bank has been preparing itself so that we can proclaim in relatively short order. But, Madam President, while insurance deals with risk, there is another aspect of insurance, again alluded to by Senator Mark, and that is the pensions aspect of insurance. Insurance is peculiar in that it has, Madam President, an interesting flow of funds associated with it. It collects annuity premiums, it collects risk premiums on an ongoing basis, and in some cases, it knows that it will begin to pay the annuities maybe 30 years from when a first contribution is received. It collects life insurance premiums from someone who is 30 years old, and in general, its actuaries tell the company that, well, you can expect to pay out a death benefit to this person having started at age 30, maybe 50 years later. It is for this reason insurance companies like you to buy policies when you are young. They also like you to buy life insurance policies when you are not engaged in at-risk activities like smoking, and they subject you to a medical examination to make sure that you are not coming to the industry with any pre-existing ailment. They will take the risk. And, Madam President, they segment people. Professionals are given lower premiums because professionals tend to engage in less risky eating behavior and things like smoking and so on. But the issue is, and I relate it to Clause 85, Madam President, insurance companies must invest. The investment arm of insurance is as critical as the risk assessment arm. Reason is the insurance receives something known as float. What is float? Float is the premium it receives on an annual basis that is not paid out in claims in that year, but will eventually be paid sometime in the future. The insurance company then has the luxury of long-term investing. It can and frequently will purchase government bonds, and I understand the reasoning behind Clause 85. It will purchase government bonds of maybe a 10-year duration, 20-year duration, and usually the investor or the investment arm within the insurance company will hold these bonds to term. They are not trading bonds. They have a stock portfolio of bonds that they will hold to term. They will collect the interest, and then they know exactly how to time their bonds with particular claims. It is in this context, Madam President, that I raise the issue of investments. And I agree with Senator Mark. Is it that the 70% may be too restrictive sometime in the future. And that if an insurance portfolio manager, the individual who, or the agency in the insurance company that is in charge of its investment portfolio, holds the view that there are investments in Brazil, there are investments in India, there are investments in South Africa, that they would like to engage in having, this is, you see, Madam President, investment is now global. We act locally, but we must think globally. The international investment, the portfolio of investments is simply huge. And it may very well be that in order to maximize returns, that they may find investments in jurisdictions outside of Trinidad and Tobago. My recommendation is once the portfolio manager sees that there are opportunities outside Trinidad, and the manager would like to invest a portion which will take him below the 70%, maybe 60%, with justification to the regulator that the investment that he considers is an investment that is going to generate a far better return with less risk than an investment within Trinidad and Tobago. I think we should allow the investor, we should not so tie the investor in the insurance company's arm, because ultimately the higher the rate of return on the investment of the insurance companies, the policyholders are going to benefit, and the insurance and the retirees themselves may benefit based upon the kinds of annuities that are going to be paid. Insurance provides, Madam President, a valuable component of retirement. For this reason, I say we need an insurance sector, strong sector, because as we age, we know that the pensions that you earn, that you obtain from your employer may not be enough to sustain you for the rest of your life. Why, Madam President? It is because of an increase in life expectancy. When you look at the charts in Trinidad and Tobago from 1960 to now, over the last 50 years, we have seen the life expectancy of Trinidadians have increased basically by 10 years. More for women.
Senator Mabe, you have 5 more minutes.
Thank you very much, Madam President. Let me see in 5 minutes, because, you know, I mean, I was getting a little an opportunity to do a little economic analysis. And so, as you understood, Madam President, all these collateralized debt obligations and things, a long time I haven't addressed them. And it's all on derivative. Senator Khan, I'm sure, if he could move a motion to get me to expand, I'm sure he would, but I know he can't. I know he would have. But, Madam President, I raised the issue in the few minutes that I have of a strong insurance sector with respect to our retired population. We know that we have an increase in life expectancy now. Someone who is retiring today may easily live up at age 60, may live to age 80. He has 20 years in which to finance the retirement. And retirement can be expensive because of paid care. And what insurance companies do then is that they sell these annuities. That is, you contribute to them from when you are young. And it is, in fact, highly recommended. And I am very happy to see that the investments that insurance companies will now engage in will be such that the annuity payments will not be compromised. We need to protect our retirees. And, Madam President, we, however, at the same time, need to ensure that the insurance companies are not in any way too severely restricted, given that investment opportunities are abound, and they are not all toxic. You see, I don't think we should make one example the derivatives, and not all derivatives, too, not all derivative contracts are questionable. The first one, that the mortgage default swap, is a very good instrument because it just offers insurance on a very good instrument. But when you offer insurance on an instrument that is very risky, that's where the problem arises. So, Madam President, we need a strong insurance sector. I think that the rules we have before us are going to be beneficial for the people of Trinidad and Tobago. We know the central bank will have to look at standards of service to ensure that the smaller people are protected for their small claims. But, Madam President, while we implement this legislation, hopefully, I know I am jumping the gun here, but hopefully we will approve this legislation. And when we do, let us, at the same time, Madam President, understand that the origins of this particular bill really are based upon two prongs. One, 2007. But second, Madam President, the origins are based upon this violation of fiduciary responsibility. And once we recognize the second component and we undertake measures to make this particular action of violating the trust that people repose on managers of money into a criminal offense, I think Trinidad and Tobago as a whole will be well served. And basically, I know we will be reviewing this legislation. While, in fact, I don't recommend that we put it in law, I would imagine that every 5 years or so, this piece of legislation will come back to the Parliament. Whoever is in office will look at clauses which need, Madam President, to be amended, will be amended, and finally, we will be able to regulate insurance as well. I thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much for the opportunity to join in this debate. Madam President, I was very pleased that my colleagues asked me to serve on this Joint Select Committee on the Insurance Bill. It is landmark legislation, Madam President, and I think as legislators, we should be asking ourselves 4 questions this afternoon. First, how will this affect our citizens? How will this affect the insurance sector? How would it affect the country? And how would it affect the region? Madam President, today and every so often when we enter the Parliament, there's a guy sitting outside with a placard. And different people. And that dates, Madam President, because last night when I was thinking about the bill, I just went through very quickly in my head in a few minutes my own experience and some of the words that have been bandied about for a long time. And pension reform has been one of them. Pension reform, harmonization of NIS with old age pension and private pensions and so on. And there are different groups of people. There's one group from the Port Authority, pensioners, who sometimes come outside the Parliament. That, gentleman, dates back to the telco days. And there are unresolved issues in the telco pension. When I was in Point 14 for Borrow Day, a man who's in his 80s reminded me of him seeking advice from me many years ago in relation to his retirement benefits from Shell. And I myself had to deal with the confusing matter of 7 or 8 pension plans in Caroni, several of them underfunded, and having to create harmony and harmonize and put them on a long-term structured basis so that the former employees of Caroni would get a minimum pension. So this bill seeks to do 2 things. And to answer Senator Mark's question about Guyana, the bill is very explicit in saying that it creates a regulatory framework for the insurance industry on one hand, but on the other hand, it continues to provide for the regulation of the privately administered pension funds. In other words, Madam President, today we are dealing with insurance, but we are not dealing with pension funds and pension plans and the administration of pension plans. We've preserved the current arrangement and left for another day to deal with pension plans. And hopefully it does not take us another 40 years to get there. Madam President, I listened to Senator Mahabir, and he used an expression, the seeds of the crisis, in reference to maybe CLICO, the seeds of the crisis. And I want to say that at the heart of what we're doing today is people. And the irony of it all is that the slogan of CLICO was people-centered, future-driven. But I'm not sure upon whom the attention was centered and whose future they were taking care of. But as we fix this insurance, and I'm just talking about human behavior, as we fix insurance today, we have in this country something that has developed that I hope it's not 40 years from today that we got it to fix. And that is this thing called cryptocurrency. Because, Madam President, the same men in fancy suits who came around selling insurance policies and insurance products are now going around the country asking people to gather in groups of 10 and fork out their money, $5,800 per person, for training. And the training involves you would get 8 or 10 coins with a value of $500, and you would get 8% interest on your $5,000 investment. And it's men in suits and bright lights and so on. And the Securities and Exchange Commission has had something to say. In March 2018, Hayden Gittins, the director, made a presentation at the Telecommunications Authority of Trinidad and Tobago Forum on cryptocurrency. And he didn't come down on one side. He talked about the benefits, but he also pointed out the risks. And my concern is that while we deal with the insurance, we are creating a problem and allowing a problem to fester that would one day grow to become a CLICO-like situation. And the two are driven by human beings and their desire for greed, their wish to take advantage of the vulnerable, and most importantly, at the root of the CL Financial and CLICO matters are an abysmal failure of regulators to do what they're supposed to do. And as I always say, this is excellent legislation. It is not perfect legislation, but this legislation falls in the hands of people who are not in this parliament. Gatekeepers who are not in this parliament, a series of gatekeepers who must certify fit and proper directors, who must ensure that administrative requirements that are required under the law are met, who must penalize administrative requirements. And Senator Mahabir, if you go to Schedule 6, you would see some administrative offenses and the administrative fines, and some of them deal with directors in their personal capacity and the failure of directors. And to me, that's a start. To put it into the act and put it into the schedule and to avoid a summary offense and a trial and all of that and create an administrative offense is, to me, gives you the ability to enforce certain patterns of behavior. But ultimately, the strength of this legislation relies on the ability of the regulators to do what they're supposed to do. Madam President, and the importance of reform, the Minister of Finance talked about the importance from a financial point of view. The combined assets, he said, of insurance company and pension plans is in the area of $100 billion, 1/3 of which is invested locally. But, Madam President, in a previous contribution, I talked at length, I think, on the issue of money laundering in this country. And I pointed to the 2017 report of the FIU. And let me just go back to this issue of money laundering in relation to insurance companies. You see, Madam President, when the FIU rendered its report in 2015, what I saw in the report was a growing trend for insurance companies to be used for money laundering purposes. So in 2011, there were only 9 suspicious transactions relating to insurance companies. In 2012, it was 10. 2013, 3. 2014, 13. And 2015, 28. In fact, in the 2015 report of the FIU, there were reports on suspicious transactions to the value of $3.6 billion. But only a small part of that, 1 million, representing 22 transactions, 1 million were attributed to insurance companies. So in 2015, 3.6 billion, of which 1,032,375 were attributed to insurance companies. Fast forward to 2017, 2 years later, and what the FIU told us in the report of 2017 was that the money laundering, the scale of it in terms of suspicious transactions, had moved to $22 billion. And when you think about the context of it, $22 billion, when for the previous 5 years, the total value of suspicious transactions for the 5 years preceding 2017 was $4.5 billion. So you're talking about a 5-fold increase in 1 year. But what the FIU also told us was that 7 billion of that were attributed to insurance companies. So the FIU made a few important observations about insurance companies in its last report. And those observations were, one, that the insurance companies were increasingly being used for the purposes of money laundering. Two, highlighted an increase in fraudulent transactions relating to motor vehicle insurance and the fraud related to fraudulent certificates, fraudulent insurance agents, and fraudulent use of fraudulent certificates to found claims on insurers. So, Madam President, just in the context of money laundering and the FIU reports, we can observe and understand that it is very important that the operations of insurance companies, the management of insurance companies, the people who serve on the boards of insurance companies, the reporting of insurance companies are vital to this country, apart from its importance in the insurance business, its importance in the anti-crime initiatives of this country, and the ability to meet our international obligations in relation to those initiatives. Madam President, I just want to quickly go through the legislation. It's a significant piece of legislation, and I can't go through all the clauses. But I want to highlight some of the things that I consider to be very important in this legislation. The first is, and I don't want to go back over the CLICO, and I don't want to go back over the issues relating to CLICO. But Madam President, it is impossible for a business like the insurance business to function without the stipulation of minimal capital. And the Minister of Finance in his contribution talked about the capital adequacy requirement. But Madam President, it is not just the stipulation of minimal capital. There are other things that go with that. And if we go back to CLICO, the fact is, all these insurance companies submit to the central bank financial statements which set out their assets. But if the regulators are not going into the submission and determining the quality of the assets, then the companies are going to continue to play the game. And what we saw with CLICO, and in a certain part of the bill, section clause 70 addresses the issue of related party transactions. But a major component of the problem within CL Financial is the use of related party transactions to support the balance sheets of companies within the group. So two things are important in this bill in relation to not just minimal capital requirement, but structuring of the company and dealing with intercompany dealings. And the two things I want to point to is the requirement under clause 65, under clause 65, where you have an insurance company that is owned by or part of a group that has other financial entities, there is a requirement that the group be separated so that the financial entities are under one holding company and the non-financial entities are under another holding company. So, for example, if you have a group where you have a real estate company and you have an insurance company and you have a company involved in lending, the real estate company and the financial related companies would be under separate holding companies. And that is, Madam President, to ensure that you do not have commingling of assets, you do not have related party transactions where you're moving funds from one company to another company. You are doing that with the use of paper. You are doing that with use of paper that is not backed by assets. And in other words, you are just fixing the books so that a regulator who is asleep and not paying attention would not know what is happening. The second thing I want to point out in relation to the legislation is the restriction, clause 30, and very simple, the restriction on an insurer from carrying on business for which it is not registered. Because what we have seen insurance companies getting into, and I would call it insurance companies that style life insurance as investment products, and insurance company that style investment products as life insurance. And a previous speaker, I think is Senator Mark, dealt with the issue of banks offering life insurance and insurance companies offering banking services. And clause 30 is very important because it confines insurance companies to the business for which they were registered. And that is supported by clause 32, which prohibits an insurer from altering its articles of incorporation without the approval of the inspector of insurance. And that ensures that everybody stays in their section, because unfortunately the consumer does not realize the risks that are attendant when people get into business that they are not registered for, they are not licensed for, they should not be doing, and they are not even capable of doing. Section 42 and 43, clause 42 and 43 addresses the issue of commingling of funds and requires that the insurers maintain separate accounts to support the various categories of insurance business. And again, very important, because part of the CL and some of the other issues we kept hearing this issue of liquidity, and we kept hearing this issue of asset and the difficulty in converting asset into cash. And what the Minister of Finance spoke about earlier is the requirement that you keep 150% of your operation expenses available to you so you could fund the business of the insurer. And by putting in these rules that allow you to, or require you to keep separate accounts and to keep people's premium in a particular account, to keep the foreign business that you do, to keep the proceeds from your foreign business in a different account. It is meant to avoid commingling of accounts. It is meant to avoid or not create the opportunity for you to interfere with the accounts and to move money among related parties, so that when you have claims to pay or when there are problems in the entity, the people who have invested in the entity and who have purchased products for which they have a lifetime interest would be able to have some sort of recourse. I've already spoken about the capital adequacy requirements. Madam President, perhaps for me, the most important part of this bill, and in a sense we've come somewhere, but it may be an area that we have to return to. I agree with Senator Mahabir, it may be an area that we have to return to. And that is the board of directors and the appointment of persons to boards and the appointment of the independent auditor. And Section 67 of the Act, Clause 67, Madam President, deals with the issue of directors, the duties of directors, and also deals with the fit and proper test for directors. And the fit and proper test, the detail of the fit and proper test is in Schedule 5 of the minimum criteria, the individuals to be fit and proper persons. Schedule 5 deals with it. But I want to point out in the area dealing with directors, I want to point to a very important provision as far as I am concerned. And that deals with, and it is not a provision that we see very often in our legislation in Trinidad. It's surely not in our Companies Act, but is a provision that I welcome, particularly in this act. And that is under 67(7), which reads, an insurer shall not award or pay any bonus to its directors and officers where the assets of the insurer are insufficient to meet the requirements under the Act and regulations, or the bonus would reduce the assets of the insurer below the amount referred to in paragraph A. And by bonus is defined and remuneration is defined, Madam President, because it is not unusual. It is not unusual for financial institutions, and it is not unusual for insurers that are on the brink, that are not servicing their insureds, that are not paying claims on time, to be paying bonuses or to be paying themselves and to be fattening themselves and leaving their insureds unattended to. And that, to me, is a very important provision. I also want to point to the audit committee of the board, and of course it says, Madam President, it's not something we see very often in our legislation. We see the audit committee, the requirement that a majority of the directors be independent directors, that is, some directors who have no affiliation to the entity, at least one of whom shall be a financial expert, and at least one of them not being connected to the insurer. But I say that very cautiously, Madam President, because we have seen even Clico and the parent company had persons on the board who were supposed to be independent and who were supposed to be qualified, and still allowed the company to get into trouble. But it is at least good in law that the legislation provides for that, and when we pass this bill, as I have said, we leave it to the regulator to ensure that people do what they're supposed to do. Madam President, throughout the legislation, throughout the bill, there are sections dealing with consumer protection. And from 255 onwards, 255 to 58, there are very important provisions dealing with the dealings between someone who is offering, like a salesman who is offering the insurance product, and the consumer herself, the customer herself. And we understand in our country, this is a very small society. I'm watching, as I said, cryptocurrency, and a lot of what is happening on account of relationships. I see some churches and so on involved in it, and I know that a lot of it is driven by relationships and people who place trust in each other. And the insurance and financial services on the whole is conducted in our small society on the basis of trust. But the legislation, for once, because I always wondered at what stage the law will get to those insurance salesmen, the fancy suits who are selling these products, knowing the weakness of the product in terms of the ability of the person holding the risk to be paid. And while we have focused on the top of CLICO, we've never drilled down to the people who were actually going to these potential insureds and not disclosing to them the difficulties that CLICO was experiencing in its own cash flow, which prejudiced its ability to pay. And of course, what would the consumer, when you go around the savannah and you see an entire wing dedicated to the insurance company, and you see all the signs of success, and all these people in the fancy suits and the $1 million, I think it's Senator Small who mentioned it in a previous debate last week, the people going to convention in Vegas and so on, and you're not realizing, $1 trillion round table, and you're not realizing that it is your premium that is flying to Vegas and staying there. And Section 255 really represents to me where we should be. It sets out in detail. It creates the offenses. It creates the penalty. And again, as I say all the time, it is left to the persons whose job it is to enforce these criminal offenses to be able to ensure that those who are cheated get their just due. Madam President, very way down in the back where nobody is likely to reach 267, there is a very simple provision that I appreciate, and I really hope that this works. And that's a provision where, because even after, and insurance is one area, especially motor vehicle insurance, attracts a lot of litigation. And some of it, from my understanding of third-party insurance and third-party insurance provider, some of it is really a management of cash flow by the insurance companies. They have their lawyers on retainer. They allow the matters to flow slowly through the legal process while they hold on to their investments, and they pay just at the point when somebody is ready to come and blow up the building. They pay out something to keep people happy. And this is Section 267 says, an insurer shall fully settle all judgment claims within 40 business days of the judgment order unless there is a stay of execution. And the provision is there. The provision is there. Right. The issue is the penalty.
But Senator, that's a judgment claim. That's not really a normal claim between an insured and the company. And this is where the problem arises for me, Before it goes to judgment, they delay at that level, right? Yeah,
Senator, that is exactly what I was saying. I was saying it's a judgment, it's a situation where it goes to court, and there is no, but there are provisions in this act. There are provisions. If the regulators are doing their job, there are provisions where a regulator can deal with a matter between an insured and an insurance company. It is just that it does not happen. And Madam President, just to go back to what Senator Mahabir spoke about, when you go to Schedule 6, you would see, for example, Schedule 6 in relation to Section 66 of the Act, Clause 66 of the bill, Section 6, Schedule 6 sets out that the director of an insurer or financial holding company being present or voting at a meeting of the board of directors or a committee of the board of directors of that insurer or financial holding company on a contract which would result in a direct or indirect financial benefit run the risk of a criminal penalty of $500,000 or an administrative fine. So, Madam President, these are things we are seeing for the very first time in legislation. This deals with conflict of interest. And we have legislation where directors very clearly are not supposed to engage in conflict of interest, but the penalty and the enforcement is sometimes very far away from the commission of the offense. And this creates the opportunity for a criminal penalty on summary conviction of $500,000 or an administrative fine of $125,000. And as I said before, there are other places in which there are administrative and criminal penalties in relation to the behavior of directors, the behavior of the insurer too, but the behavior of the directors. Madam President, I don't want to abuse my privilege to have served on the committee and to have said my piece, and I thank you very much.
Honourable Senators, at this stage, we will suspend the sitting and we will return at 5 p.m. So the sitting is suspended until 5 p.m.